Are you a J-1 visa holder and thinking about filing an EB1A green card petition? But maybe you have heard that you cannot file because of the 2-year home residency requirement, or that J-1 is a single intent visa and won't allow immigration intent. Here's the good news. You can absolutely start your EB1A I-140 petition today and lock in your priority date without needing a J-1 waiver at the time of filing stage. I'm going to explain the rules, clear up common myths, and give practical guidance for J-1 scientists, all based on experience and publicly available USCIS regulations. But let us quickly understand what is EB1A. EB1A is the Extraordinary Ability Green Card for people at the top of their field. It's self-sponsored, meaning you do not need an employer to file. The petition form I-140 shows your qualifications. These can be in terms of any of the 10 criteria listed by USCIS and meeting final merit determination. For example, publications, awards, citations, leadership and impact. USCIS evaluates whether your achievements place you among the very top in your field and that you have sustained national and international acclaim. Crucially, your current J-1 visa status does not prevent you from filing the I-140, even if your visa has 2-year home residency requirement. USCIS will accept the petition. Approval depends solely on the merits of your EB1A evidence and not on whether you are on J-1 visa or not. Let us also quickly understand what is 2-year home residency and how does it relates to the I-485 or consular processing during your adjustment of status. Some J-1 visas include the 2-year home residency requirement called Section 212E. This requirement only matters when you adjust status to a green card in the US by filling Form I-1485 or apply from an immigrant visa at the US consulate. It does not prevent filing the I-140. You can submit your EB1A petition, receive approval and secure priority date. Later, if needed, a waiver can be requested for adjustment of status using options such as number 1, a no obligation certificate or statement from your home government, second, a hardship waiver, or third, an interested government agency IGA waiver. Starting your EB1A petition early does not violate your J-1 status and keeps your options open. So what is single intent versus dual intent visa confusion? The J-1 visa is generally a single intent visa intended for temporary study or research or exchange work. Many J-1 holders worry, if I file EB1A and for that matter even NIW, am I violating any visa rules? Filing an EB1A petition does not constitute a legal violation of your J-1. The US government allows non-immigrant visa holders including J-1 or F-1 to submit EB1A petitions. The single intent nature only becomes relevant if you adjust status in the United States without fulfilling the home residency requirement if applicable. The key takeaways: filing EB1A is permitted and safe. It does not create legal problems while your J-1 status is valid. So why filing early matters? It is important to keep this in mind with respect to the timeline and priority date and adjustment of status as well as waiver. Filing EB1A early has several practical advantages. Number 1, it locks in your priority date, which is critical if your field has many applicants and there is a long queue. Second, it shows recognition of extraordinary ability. USCIS approval reflects your top level achievements that you can leverage if you are looking for something like an O1 visa to work later. 3, provides flexibility. You can plan J-1 waiver or consular processing later. Even if you are still completing your J-1 program, starting your EB1A petition helps secure long-term US immigrant path without violating visa rules. So here's a practical strategy for J-1 scientists. How do you approach this safely and effectively? Number 1, file your EB1A I-140 now. No waiver is required for that stage, and in the meantime you can work on another visas like O1A, H1B, or continue to work on J-1 visa. Second, build a strong petition, include publications, citations, awards, leadership and impact. Number 3, plan for adjustment or consular processing. Later decide whether a waiver is needed. Number 4, seek professional guidance An experienced immigration attorney or a consultant can review your strategy and ensure compliance with J-1 rules. Remember, EB1A is about demonstrating your extraordinary ability, not your visa status. So this is what I would like to say before I end. And this is very important. So yes, J1 scientists can file EB1A I-140 without a waiver and secure their priority date while remaining compliant with US rules. But I want to be clear, I'm not a lawyer, I am an advisor at Green Scientist, but I have helped hundreds of immigrants file EB1A while on J1 visa, working closely with our partner immigration attorneys who have over 2 decades of experience. If you want to talk to a consultant at Green Scientist or one of our partner immigration attorneys about your EB1A options while being on J1 visa or about your NIW options while being on J1 visa, fill out the evaluation form which will be in the first comment. We will help you schedule a personalized meeting to map out your safest and most effective path to a green card. I will be seeing some of you at Green Scientist and I look forward to meeting you. But even if I don't, I really wish you good luck and I really hope you get your green card on time because it is the path to freedom and you being an extraordinary scientist deserve it very well. All the best.